And 1 second, we're just making sure that my screen can show up. So we're going to review COPPA's requirements: a privacy policy, making sure you have one, direct notice to parents, getting parents verifiable parental consent, and of course, for those of you that are collecting data from children, because this is considered sensitive data, securing it with reasonable data security methods. We're also going to talk about a very important exception to COPPA, which is the internal operations exception. Then we're going to delve into what is called the actual knowledge problem and how a TUNE COPPA flag, which we will also talk about, can help advertisers address this problem. We will also go into some detail into the FTC's recent action against TinyCo, which is a developer of a number of apps, including some which the FTC deemed as kid-directed. We will also discuss a little bit the recent action by the FTC against Yelp for its improper use of an age gate. And finally, we will close by identifying some next steps and resources. So now first we will talk all about COPPA. What does it involve? What is it? So contrary to some assumptions out there, COPPA does not prevent you from advertising to children. It permits targeted advertising to children so long as there is the right form of notice and what is known as verifiable parental consent. So parental here refers to the child's parent or guardian. Unlike a lot of advertising best practices and frameworks, COPPA is an actual law. It's not a best practice framework. The penalties are $16,000 per violation, and it's generally viewed as one of the strictest privacy laws, both in the US and globally. COPPA was passed in 1998, and for those of you who are following the law, it was revised significantly last year, and we will discuss some of those updates in this session. COPPA is enforced by the Federal Trade Commission, which has primary authority to enforce various US privacy laws, including HIPAA, the Health Information Privacy Protection Act, FCRA, the Fair Credit Reporting Act, and also Section 5, which prohibits you from doing anything that's deceptive and or unfair. And the FTC has generally used that Section 5 authority to bring several actions in the online privacy space. But COPPA is separate because it is a law, so you will often see a COPPA action accompanied by a Section 5 claim. But since COPPA gives the FTC the ability to get penalties, it's definitely an area of focus for them. The FTC, of course, being the most active privacy regulator in the world, they pursued 31 privacy actions for a total of $64 million in fines. As many of you know, the FTC actually has two bureaus, a Bureau of Consumer Protection, of which privacy is one area of focus, and then a Bureau of Competition. So even in the privacy space, this is a fairly active regulator. And when the FTC has deemed that you've had a COPPA violation, then that violation can also lead to violations of state law. So you may see follow-on actions from a state AG if you are in the unfortunate position of having an FTC settlement against you for a COPPA violation. So who does COPPA apply to? Well, COPPA applies primarily to website and app developers. So website operators and app developers, what we call often publishers of content. It specifically applies to three categories of sites and apps. Sites or apps that are directed at or targeting children. So for those of you who followed the TinyCo case, Tiny Pets and Mermaid Games, these were sort of apps that the FTC found to have content that was specifically directed at or targeting a child. And we'll go into those factors later in the session. The second category of sites or apps to whom COPPA applies are sites or apps that target children as one of their audiences, even if children aren't a primary audience. These are known as mixed-use sites or apps, and Yelp is a good example, and we will go into the to-dos for these sites or apps. later on in the session. And then finally, outside of sort of kid-directed sites or apps or mixed-use sites or apps, any site or app that has, or third party rather, that has actual knowledge that they're targeting children, COPPA applies to those sites, apps, and third parties. And we will go into that in a little more detail. So let's first dig into the requirements. Why do so many feel that COPPA's requirements are onerous and extremely strict? And it's really given where COPPA arises in the sort of marketing and advertising cycle. It requires that companies give notice to parents and get verifiable parental consent before targeting the child online for advertising and marketing purposes. So specifically what you will need to do if you determine that COPPA applies to you is that you'll need to provide a privacy policy that outlines how you're collecting data from kids, the contact information for all the third parties on your site and app. And by third parties, we mean companies like TUNE that might provide analytics to you, any sort of advertising networks that are on your site. You'll at least need to note that in your privacy policy. We'll talk later about internal operations and how some of those activities are exempted, but you'd still need to note that in your privacy policy. And also you need to note how parents can review, delete, or prevent further collection from kids on your site or app. So that privacy policy needs to be in place from the get-go. Then once the child starts interacting with your site or app, you'll need to provide a direct, and the FTC has actually expressed a preference for just-in-time notice. So right before you're collecting information from the child, personal information from the child rather, you'll need to provide direct notice to the parents. And then finally, you'll need to obtain the parents' verifiable parental consent. And only after these three requirements have been met can you, for instance, collect the child's email or sort of let them provide you the information needed so that they can engage further with your site or app. Now, companies collecting data from children, again, this has been viewed by the FTC as sensitive data, and COPPA provides specifically that companies need to take data security measures to protect information collected from children. This includes data retention limits, limiting the access to the data after a set amount of time, and then keeping data only for as long as necessary. So now that we know what COPPA requires, let's delve into what constitutes personal information under COPPA. So if you're collecting the following categories of information and using that information in any way to target advertising to a child, then COPPA applies to you. When the law was passed in 1998, the types of information were first and last name, home, physical address, telephone number, social security number. With the 2013 updates, we now have email addresses, persistent identifiers, which includes cookies and device identifiers, geolocation information that is sufficient to identify both a street and a city and town, photos and videos that contain a child's image, even if there's no other contact information in that image, screen names, online usernames, avatars, anything that allows you to contact a child online is now also considered personal information under COPPA. Now moving to the next slide, we're now going to talk about the internal operations exception. So we've established that COPPA requires you to provide notice and get verifiable parental consent if you're collecting certain categories of personal information for targeted advertising. But what if you're collecting device identifiers to help you attribute your users, as you would be doing if you were using TUNE's MAT solution? Then there is an internal operations exception, and that exception covers all data collection by the site or app that is related to helping the site or app's internal operations. And that includes, as you can see, there's a pretty extensive list of functions here covered by internal operations. Billing, if you're serving contextual ads, i.e. not targeted ads, frequency capping, anti-fraud measures, if you need to collect data to comply with a law or regulation, if you need to authenticate a user, if you need to personalize content, or for that one-time contact to a child or parent asking them to provide providing the notice and getting VPC for them. These are all instances where your data collection will be exempted under COPPA. Now, on the next slide, we're going to talk about who COPPA does not apply to. So you may be a child-directed site or app, and you're not engaged in targeted advertising, only in contextual advertising, and your data collection falls within those internal operation exceptions that we just discussed. You may also have a third-party plugin, and that plugin is okay if the plugin only collects persistent identifiers and has a so-called direct relationship with the child user already, including an age screening mechanism. So I believe Facebook and Twitter now have COPPA-compliant plugins. So if all of these instances apply to you, then COPPA does not apply to you, because again, COPPA applies to the collection of data from children for targeted advertising purposes. A second category of companies that COPPA does not apply to are the so-called third parties. The FTC uses first party and third party quite often, first party being the site operator, the app developer, the publisher of the content, and the third parties essentially being everyone else. So third parties include ad networks, plugins, others. Unless these sites have actual knowledge that the site or app, or that your site or app markets to children, they do not have any liability under COPPA. You, the site or app, does. So that's a really important issue. It's called the actual knowledge problem by some, and we actually will address it later on in the presentation, as there's been a great initiative that was actually started at TUNE even before I got here that helps address the actual knowledge problem. So for those of you who have looked at the FTC's COPPA guidance, particularly their FAQs, you will note that actual knowledge is really a specific affirmative representation from a site or app to these third parties saying we are child-directed. So you need to have that specific representation. You can't vary it in your terms of service. You need to actively represent that you are child-directed, and if and when you do, then third parties you deal with would be deemed to have actual knowledge that your site or app markets to children. Now we'll take a little look at verifiable parental consent. So this is for sites or apps that have talked to their legal counsel and others and said, well, we are definitely subject to COPPA. Let's pursue some verifiable parental consent, or VPC, options. And there's some ways that you can implement VPC under the FTC's rules. The most common way is just to get a consent form signed by the parent and have that returned by email or fax. Providing a credit card or government-issued ID is another form of verifying the parent. You can also use an FTC-approved VPC vendor. There are a few of them out there. Imperium is one of those VPC vendors. It uses KBA, or knowledge-based authentication, so-called challenge questions, to determine the identity of the parent. Another company is Assert ID, which has integrated with my former employer, Trustee, and they also offer a VPC solution. And then we have a few graphics here that show different screens in AgeCheck's VPC process, and AgeCheck is another VPC provider, and their application is actually pending before the FTC. I think that comment period ends this week, but they are also seeking approval from the FTC for their VPC solution. So if you look at these diagrams, and unfortunately they're not in the order that they would normally arise, we have a diagram that shows that a bit better on the next slide, but these are just examples of different types of notices. And obviously, as the publisher, you would have some leeway in designing this, but essentially you need to provide notice to the child that they need VPC before progressing to the next stage of the game, if that stage involves you collecting their personal data. You need to provide a prompt for a parent to provide the VPC, and then there's of course an example of notice to parents as well. So on this slide, we're going to walk through the process of VPC, and of course this is really just a sort of an example. There will be a lot of variations in this process depending on your user experience and other factors, but essentially you want to make sure that you have a privacy policy in place already. The child downloads the app. In the first scenario, the app is collecting personal information from targeting, and all of this personal information collection is falling outside of the internal operations exception. So if the app is collecting personal information from the get-go, and again, that could include geolocation information, persistent identifiers for reasons outside of the internal ops exception, etc., then at that point, the app needs to stop, inform the child that they must get parental consent first, and then the child cannot access the app until that verifiable parental consent is received. In the second scenario, an app does not automatically collect personal information for targeting. The child is sort of allowed to play with the game or app, but then at one point they are prompted to enter their email address, create a profile with the app to reach the next level of the game. When that happens, or before that happens, the app needs to inform the child about parental consent, and then once the notice is provided to the parent and parental consent or VPC is received, the child can continue with the game. So that's essentially the two scenarios of how VPC might play out for a game or app, either using a VPC provider or if you as a site or app elect to do the VPC yourself. So let's delve in a little bit into what is a kid-directed site or app or content. And this was explored recently in the FTC's settlement with TinyCo, a developer of several games, including several that the FTC determined were kid-directed. In the TinyCo case, there were actually two ways that the FTC determined that the apps were kid-directed. First, there was actual knowledge. TinyCo had a number of parents contacting them to complain about data collection from their children, and TinyCo ignored those emails and calls. The second set of factors that the FTC would look at is your subject matter, and they would look at that objectively using the following factors: visual content, especially the use of animated characters, child-oriented activities or incentives. And by incentives, we're really talking about incentives that are kind of encouraging the child to give up their personal information. So, send us your email and we'll give you 5 gold coins. I think that was one of the examples that the FTC found in one of the TinyCo games. Using child celebs or celebs that appeal to children. Obviously a lot of debate with that second category. And then there's this catch-all category, other characteristics that demonstrate children are being marketed to. And then the FTC also looks at evidence that children were an intended audience of your site or app. They may look at your business plans or your marketing plans and determine that even though you may have thought the content was not kid-directed, that the content was indeed kid-directed, and COPPA applies to your site or app. Next, we'll talk about mixed-use sites. So we've already covered where COPPA applies in terms of a site or app that has content that's attracting children, kid-directed content. But what about sites that aren't specifically targeting children under 13, but there is some content on there that could be attracted to them, and you know that they could be a part of your audience? Then you are what is known as a mixed-use site. And for mixed-use site, the FTC COPPA rules require implementation of an age screening mechanism, and there is plenty of instruction in the FTC FAQs about how this age screening mechanism should work. It should be quote-unquote neutral. And there are some factors here that are were explored in the FTC's case against Yelp. So Yelp had an age gate. They had an app, and they knew that children under 13 were using that app because they had an age gate. Unfortunately, they weren't actively screening out users who were under 13 years of age with that age gate. So that's something you should definitely do once you implement the age gate. But even the way you present it has to be neutral. So you've got to include fields for a child to enter their entire birth date accurately: the day, the month, most importantly, the year. The other recommendation, not requirement, but it's a recommendation in the FAQs, is to use a cookie to prevent so-called back-buttoning by children who discover that they need to enter a different age to enter the site. Another recommendation is not to use tick boxes. And then probably one of the most interesting recommendations is don't encourage users to falsify information. And the FTC FAQs actually give this example. Users don't use a notice that says users under 13 are not allowed to use the site. So definitely encouraging you to be creative here. And it appears that the FTC is well aware that in many cases the child is more technically savvy than the parent, and they're trying to introduce some ways to mitigate that and get the child to accurately enter their age. Don't know how much that will be successful. There's definitely been some scholarship out there about age gates and the fact that they don't work that well. So now let's talk about TUNE and COPPA and what TUNE is doing. We are, of course, COPPA compliant ourselves. The MAT technology in particular is based on the device identifier of the child's phone or other device, and we are collecting that for the sole purpose of helping our clients determine attribution. So we fall within the internal operations exception. But by virtue of where we sit, we also are seeing sort of the fact that a lot of our advertiser clients are responsible for COPPA, and we're also seeing a lot of ad networks that want to engage in targeted advertising but want to do the right thing by not engaging in targeted advertising towards children. So this is a fairly difficult problem for advertisers to manage, and of course the 2013 COPPA amendments state unequivocally that it is the site operator or app developer that is on the hook, and that third parties are only liable if they have actual knowledge. Now, that the site or app is marketing to children. Actual knowledge is actually a really easy standard to satisfy. You can notify the site, app, or third party by email, phone, or other methods. So, at the end of the day, there's a lot of uncertainty in terms of, whether a site is child-directed or not, whether COPPA applies. And TUNE has been thinking about these problems, and like I mentioned, even before I arrived here, the team here had come up with the idea of implementing a COPPA flag. So a COPPA flag is essentially a signal that the site or app would send, and it's essentially a do not track for kids signal. And it really provides transparency, because for those advertisers and third parties that want to market to children but want to do it in the right compliant way, a COPPA flag provides transparency. So once the site or app notifies the ad network, for instance, that they do have content directed to children, then the ad network should adjust its advertising accordingly, only using approved analytics, no retargeting, no OBA, contextual advertising if permitted. And the implementation of the COPPA flag is something that's already been set up in the MAT platform. It's basically an opt-in for our advertiser clients. We're currently working with our ad partners to create a list of compliant ad networks and other third parties. And the advertiser will work with the advertising partner to confirm the response to the COPPA flag. So if you're an advertiser, it's a good idea, if this is something that you want to do or turn on in our system, to reach out to your ad partners and say, this is something that we're doing. If this flag is up, you're only to serve contextual advertising or whatever it might be. Now, the COPPA flag idea was actually proposed by the chief technologist at the FTC. The FTC has since come back and said, look, if a site or app basically states definitively for all of its properties that they are child-directed or subject to COPPA, a so-called forced choice, then we would sort of approve that mechanism as a safe harbor. So to be clear, the TUNE COPPA flag as implemented right now is not a forced choice, but it's definitely a direction that we could go if there's interest from the community. Because it would be, having a safe harbor would definitely bring some transparency and confidence to the market for kid-directed apps and also for kid-directed advertising. So again, I mentioned earlier that there is FTC support for a COPPA flag. It was first proposed by the FTC's chief technologist, Steve Bellovin, and just restating here that if this COPPA flag was a forced choice, then it could result in a safe harbor for advertisers who use it. So some final thoughts before we go to questions. We've included a list here of notable FTC COPPA cases. I think these are all the significant cases from 2008 onwards. As you can see, each of these cases involves either kid-directed content or actual knowledge. A couple of them are also mixed-use sites. And let me also say that each of these COPPA actions were also accompanied by a Section 5 action stating that the site or app's privacy policies were either deceptive or unfair under the FTC Section 5 authority. So just a thoughtful list for those of you who are interested in this area. We also see, fines that are sort of all over the place, but still significant, generally approaching $1 million. For the sites that had lower fines, some of these were sites that didn't collect any fees from kids, but you're still going to get fined even if you're a free app. So next steps is really determining whether COPPA applies to you, and that is going to involve a very serious look at your content and intended audience and a determination with your legal counsel about whether you're targeting kids under 13. And another area, of course, to investigate is if you're being contacted by phone or email by parents of children on your site and app, then if you're contacted by parents, then that would constitute actual knowledge that a site or app was subject to COPPA. In some cases, you may be a children's site or app that's only doing contextual advertising. All your data collection falls within COPPA's internal operations exception. In those cases, COPPA would not apply to you. But if you determine that COPPA does apply to you, then you should do the following. Have a privacy policy, have that set up first thing, and make sure it details your data collection from children. Provide direct just-in-time notice to parents, get their verifiable parental consent, deal with other advertising companies that have responsible privacy and data security practices that mimic yours, and if you're a mixed-use site, implement a neutral age gate and make sure to screen out those under 13 users. So with that, we come to the end of the webinar. I see we have several questions, and I will get to answering those. But for those of you interested in the COPPA flag, we have a few links here, including the FTC staff's endorsement of a flag, the original post from the FTC's chief technologist on a COPPA flag, and also a post by the privacy think tank Future of Privacy, of which TUNE is a proud member, and their thoughts on a COPPA flag and safe harbor. And of course, if you're interested in the COPPA flag and sort of understanding how it works and if it might work for you as an advertiser, please get in touch. And also ad partners interested in participating, we'd love to hear from you. So now we will go to the questions. Is there such a thing as COPPA certification or authorization? yes, there are, I think, 4 or 5 companies that offer COPPA certification, including Privo is one, Privo, and then, of course, my former employer, Trustee, offers a pretty comprehensive COPPA certification, and they've recently teamed up with a provider to also give you the VPC, so it's a more of an end-to-end solution. What age range are children including in? So COPPA applies to kids who are 13 and under. 13 and over, COPPA would not apply to you. Got a question from Eric, who's a brand advertiser. He's running an ad that allows for the ad to be shared via email, and it runs in an app that is kid-directed. Yeah, I think there are some concerns with this email share feature. Well, first of all, the app is going to be responsible for all activity. So if you're a third party running an ad in that app, I would assume that you are talking to the app about that and making sure that you're referencing their privacy policy. If you're collecting email addresses from a child in this scenario and would need to obviously need to learn more about what you plan to do with that data, but I would think that COPPA does apply to you because email addresses are personal information under COPPA. Assuming that the video ad is some form of targeted advertising. So, but again, you're not on the hook, the app is. This is the actual knowledge problem. Yeah, there's also a question about a Facebook plugin and what happens if you ask users to log in with FB inside a mobile game to share content. So assuming you're not doing any other targeted advertising on your site, just contextual advertising, and you have this plugin, what the plugin would need to do, in this case Facebook, is, well, Facebook would need to have a relationship with the child and have age screened the child first. And I believe Facebook has a COPPA compliant plugin that allows you to do that. So, you know, assuming no other targeted advertising was happening within the game, you were doing contextual advertising only, and you had this plugin that met those requirements, you would be okay. So we got a question from Aaron. What about websites or apps that don't seek to target children but might accidentally attract children through characters or social media posts? Can you be taken to task if you demonstrated that at no point you ever sought to target kids? Well, you can in this instance if you have actual knowledge that kids are using the site. So just because you didn't create the site to target them, but they now are somehow interested in it, and you know that from a parent's emails, you know, the COPPA FAQs that the FTC put out also talk about you know, the instance where you might be moderating an online forum and a child speaks up and somehow discloses that they're under 13. Yeah, actual knowledge is it's an easy standard in some ways, and so in those instances you will be responsible for kids on your site if you actually know that they're on your site, irrespective of whether you sought to attract them in the first place. Why do we? Yeah, it wasn't quite. There was a question from Isabella. What if you offer a user to contact you via email from within the app? Is it necessary to have some kind of gate in place? So I'm not exactly sure what this question means, but an age gate, a neutral age gate, is what you would implement if you're a mixed use site like Yelp. So that's the only time that it would come into play. You wouldn't be implementing an age gate on a kid-directed site. You already know that everyone on that site is under 13. Mark had a question. We provide a site that attracts kids, but to use the site we require a credit card. We also offer a free trial. Do we have COPPA concerns because of the free trial period during which no credit card is required? Yeah, if you're a kid-directed site, my recommendation would be to get the credit card number, maybe not charge it, but to use that as your authentication. and also to use that information to provide the notice and get the VPC. You at least have that on file, and of course you'll need to protect that as personal information, make sure that you're securing that data properly, etc. But you could always opt not to charge the card until the free trial is over, and again, consult with your lawyer, but just looking at the question from here, that's what I would advise. We got a question about age gates from Julia. Why do we see more and more age gate mechanisms in place for mobile games if the FAQs state that the age gate is enough protection? So I think this question is confusing two things, but again, the FAQs from the FTC state that if you're a mixed-use site, then you implement an age gate. And that's presumably why we are seeing more age gate mechanisms. Of course, they need to be neutral and implemented correctly, as the Yelp settlement teaches us. But the age gate only offers you protection if you're a mixed-use site. If you're a kid-directed site, then you need to go through the entire COPPA compliance cycle. You know, having a privacy policy, providing direct notice, getting VPC, having the right procedures in place to secure the data. And then we have a final question from Pavel. Our app allows the user to create a card with pre-selected information and share that card with their friends. We do not see any of these email or collect emails in any way. The communication is strictly user to user. Does COPPA apply to us? So again, it's not so much about the data collection in this case. It's going to be about your content and whether you're targeting kids. If you're a mixed-use site, in this instance, I would put up an age gate. If you're a kid-directed site, it doesn't matter what the features are. I think the focus is going to be your content and your audience. And I think that's how the FTC might make the determination that COPPA applies to you, but it's difficult to answer that without knowing anything else about your app. In any event, I think that is it for questions. And I will check in with Greg. Okay. We have one last question. In the event you accidentally collect kids' information, is deleting anonymizing enough to minimize COPPA exposure, or are there other things you should do to limit your risk? Aaron, this question really depends on whether you are a first or third party. So if you're a first party, my recommendation would be to get your privacy policy updated, get your direct notice and your VPC going so that you can collect more information with the right kind of notice and parental consent under COPPA. If you're a third party, so you're an ad network or other ad firm, then remember the standard is actual knowledge. So if you didn't know at the time, COPPA does not apply to you, and there is no sort of retroactive liability. But I think it's a good and responsible thing once you learn to delete or anonymize the data to the extent that you can. The FAQs actually go into this as well, and they state, well, if you've already sort of segmented the data out and you can no longer identify which is the child's data and which isn't, then that's okay. You do what you can, because again, only if you had actual knowledge that you were collecting kids' information, assuming you're a third party, then you're on the hook. Otherwise, you sort of do what you can to minimize it, but there is no retroactive liability for you. And I believe that is the end of our session. If there are any remaining questions, we will do our best to get you an answer offline. And I wanted to thank you for your time and attention today. This is, as I mentioned, my first webinar and hopefully not my last for TUNE. We intend to continue this discussion as part of a bigger discussion as how we as advertisers and marketers can do a better job marketing to our audiences within the limits of the law, but also in a way that continues to make us fresh and innovative. So thank you for your time. Again, please reach out if you have any interest in the COPPA flag, and we look forward to chatting with you again soon.